SJC-11251, Commonwealth versus Eric Denson.
Attorney Curhan, whenever you're ready.
Good morning. May it please the court, Dana Curhan for Eric Denson. The identity of the assailant here was the central issue at trial, and there were some questionable identifications that we contend substantially contributed to the verdict. It includes Michael Shea, who specifically identified Denson at trial, but they also included Tony Taylor, who identified the gas station photo as depicting the assailant, and other witnesses who provided descriptions. I think the problem here is that Taylor threw two people out of the club 3 or 4 minutes apart. As somebody described as a troublemaker, a black male troublemaker, and Denson, or I'm sorry, the assailant, who was also a black male. And we contend that there's a reasonable possibility that the witnesses may have confused the two. So in connection with this, defense counsel sought to call Dr. Stephen Penrod, who is an expert on eyewitness identification.
Mr. Curhan?
Yes.
Just before you get into that, on the ID, putting aside that this is before Collins and Creighton, and putting aside that the Commonwealth doesn't argue in its closing the Shea ID, is this an ID of he's the assailant, or is this the an ID based on the hat, clothing, and who's left at what particular time and went over to the race mart?
I disagree that the Commonwealth did not use the Shea identification. There was one passage where he said something like, just looking at the people who knew him, or something like that. But I don't think that's disclaiming Shea. When you look at, I think it's volume 19, pages 63 and 74, there are specific references to Shea's identification testimony. So he identified him as the person Taylor was throwing out. He identified him as the person he was chasing. And, you know, I think that the identification testimony was pretty clear that, I mean, he kept referring to him as, I think, the stabber and things like that, and was very clear that he was identifying Denson as the person who did the stabbing.
But he never said that, right? He never said that, didn't he refer to him as the person who left at a certain time and then went over to the race mart? He did, maybe I have this wrong, but he's not saying he was a precipient witness to the stabbing, is he?
He is. Well, he didn't say, I think he said he looked like a second after the stabbing had taken place, and he started identifying him as the stabber. And that was, there were objections sustained, and then there was a voir dire. And then after the voir dire, the judge said, okay, he comes in, and then he gave full identifications of him as the person he chased, the person who was thrown out, the person who stabbed my friend Connor. And so, you know, unquestionably, that was an unequivocal identification of Denson as the assailant. So that really, I mean, that's actually the second issue, and I can start with that because I think Creighton and Collins make it very clear that this is improper. In Collins, the issue was not preserved. It was raised as ineffective assistance. In Creighton, the issue was preserved, And I think in my brief, I said it was overturned on other issues. It was actually overturned on this issue plus two other issues. And I think when you look at this in that context, there were specific objections, there were motions in limine to exclude it. I mean, there was the voir dire, and there was a motion for a mistrial. There were all these things that happened, so it was extremely well preserved. And there were other issues that I think contributed to the conviction here.
But so that you can have a chance to respond to the Commonwealth before they say it, they're going to say, this is not an ID of what a person looks like. This is an ID based on, Taylor took the person out. They're going to go through the clothing. There is a red hat, black hat issue at the brim. But they're going to talk about this is the person who ran across. So they're going to argue that this is not a quintessential ID, that's the person. And so rather than not be able to respond to that, can you address that issue?
Well, I mean, this was a specific identification of the assailant as the assailant. I mean, he may have not been looking at him during the second that he stabbed him, but as he was turning away, that's when he identified him, where he identified him and.
But I'm not asking the question right, I guess. It's not because, he looks like the person. It's because they're following the person has certain clothes, the person's the first one out, the person runs across the race mart, they follow him. You I'm sure, have a very good response to it, but that's what they're going to say.
Well, I think they did, he did identify him as the assailant, not necessarily based on the description. He came into court and said, Eric Denson's the guy who did it.
You're talking about Shea at this point.
Shea.
But so I think I have the same concern that Justice Lowy has, though. We've got a bunch of different identifications, some by people who know the defendant, right?
Right.
That why don't you walk through it? There, like 5 or 6 people are doing IDs at the same time here, right? We've got Shea, we've got Taylor, we've got his cousins picking him up or whoever in the car, right? It's sort of a tracking device, right? Yeah.
Right, and I don't really have an issue with the people who knew him saying, yeah, that's Eric Denson.
Right, but I think that's what Justice Lowy's getting at, right, is that we've got, at a certain point, we know we've got people who know the defendant identifying the defendant. Earlier, we have Taylor drawing a distinction between 2 different people, right, and where they leave and which door they go out of, right?
I'm sorry, there was the troublemaker and there was the assailant.
And Taylor identifies the 2, right, and says he threw one person out one door and the other out the other door, right?
That's right.
And there's blood on the door, one door, and not the other door, right?
I think that's right. The problem is that there's a real possibility that some of the people who didn't know him, none of the people who did know him had anything really specific to say identifying him as the assailant.
Yeah, so could you just sort of an offer of proof then? If the expert, I mean, everyone recognizes this guy as an expert. I mean, we even point him out, right, as one of the leading. So what would he have testified to in this context, and how would it have helped the defendant? I'm just trying to understand it more precisely.
Well, the offer of proof essentially tracked the Gomes factors, the 5 Gomes factors. And
So be more precise. So in this context where we have identification of the defendant by people who know him once he's out of the building, and it would undermine the Shea identification, or is that what it would undermine?
it would undermine the Shea identification as well as the people who didn't know him who gave descriptions of his clothing.
The expert would have testified that Because it's clear the guy's wearing a hat with either a red brim or a red hat. I mean, I'm just trying to understand, what would the expert have testified on that point that would have helped you?
Well, I mean, I think he would have testified on, generally on identifications, and the problem is that the judge gave the Rodriguez instruction.
Right. And then he also gave a cross-racial identification instruction too, right?
He did.
And a good faith.
Very briefly, but the thing is, the Rodriguez instruction, which is based on, it came out in 1979 and was based on a 1972 case. The Rodriguez instruction essentially says use your common sense. You know, people might.
Yeah, I get that part of it. I'm trying to understand though, so like he would have testified that people make bad IDs because they confuse clothing with faces, right? That's one of the points that he was going to make. But I don't understand how that works in this case.
I don't think he would have given specific instructions as to, you know, people say there was a red hat, maybe it was a black hat. I think what he would have said is that human memory does not operate like a video recording. He would have talked about a witness's level of confidence. That goes directly to Michael Shea because he was very confident of his identification. He would have talked about high levels of stress that can reduce the likelihood of making a proper identification. He would have talked about information from other witnesses or outside sources that can affect the reliability. And of course, Shea and others had seen Denson's picture on TV.
But when you look at Fenton, for instance, who testifies that he saw the assailant being taken out of club, and you look at Hudson and you look at Alvarado, and they're talking about the assailant is taken out. None of those people are saying, oh, the defendant looks like that person. They're saying that's who they followed going out. I mean, honest but mistaken ID was given, but how does what the expert would have said, help as it relates to that kind of identification? I think that's what Justice Kafka is asking, and I'd like to try and understand.
So Ashley Hudson and Harmony Alvarado both knew Denson. So I don't have a problem with them saying that was Eric Denson. But here is the problem. Ashley Hudson testified that Denson was thrown out of the mailbox door. That's the one near the pool table where the assailant was thrown out. Harmony Alvarado testified that Denson was thrown out of the entry door, not the mailbox door, and she saw no one thrown out before Denson.
Yeah, that's a good point, and he doubles down pretty hard on that.
Right.
That's a good point. That's certainly important.
And of course, you know, somebody did come out after after he got thrown out. That's the taller guy.
Right.
And that's the one he ran off with. And the taller guy, there was one witness who testified that the assailant was a taller guy. Now, the Commonwealth says that that is one of the victim's friends. But, you know, I think it's really up to the jury to make that determination. And I think there's a real possibility in this case that the witnesses confused the troublemaker with the assailant. Now, there's, you know, there is a real possibility here that Denson was the troublemaker and not the assailant.
Except you've got the issue of the blood in the Saturn.
You do have that, but you know, there were a lot of people who were covered with blood from the victim.
Not the person who went out first.
Well, the person who went out first remained in the parking lot for some period of time, and he ran off with somebody who had been in the club, who possibly could have had blood on him. Now, I'm not saying that the evidence isn't legally sufficient. What I am saying is that the jury should have been permitted to hear testimony that, you know, there are problems with eyewitness identifications, and those problems potentially could have, they're counterintuitive. They're not common sense. They're not, the Rodriguez instruction is not sufficient.
So you got to deal with the forensics, though, and the error from your perspective as a matter of strategy of calling Dr. Bernstein. And the problem here, obviously, is that there's a one in, it's a randomly person that's 1 in 2.55 quadrillion as it relates to the blood in the Saturn, and you've got it on the inside handle. And when you're dealing with that, I mean, there's only really one way out of that, and that is to raise serious questions about the quality of the investigation. And Dr. Bernstein has all sorts of baggage that you very effectively point out, but without him, you got how's the blood in there?
I mean, I think I think a jury could very well have found that the blood evidence and the DNA evidence tied Denson to the victim. The question is, were there other ways he could have gotten blood on him? Now, again, I do not dispute that the evidence was legally sufficient to support the conviction. What I dispute is that there is a reasonable possibility that had the jury heard evidence from an expert on, here, if you're considering the confusion between the troublemaker and the assailant, maybe everybody has made a collective mistake, or a lot of people have made a collective mistake.
But does that work with the, I'm going back to the ID. So we now know that the defendant has the victim's blood on him. Otherwise, it's not in the car. We've got two different possibilities on ID, right? I'm just wondering whether you can't have the ID problem be that big a problem, given the, we know there are two different people who could have possibly done this, right? But the defendant has the blood on him, and the other person is removed before everything happens. So I'm just wondering whether the ID problem that you're identifying goes away, because it's clear that we got two different people, and the only question is, do we have them mismatched somehow? But
Nobody
that
ever
wasn't very
identified the
clear, but-
troublemaker. Nobody ever came forward and said, oh, I know who the troublemaker was.
The troublemaker, though, really can't have the blood on his hand, right? I mean, there's just
The troublemaker can actually have blood on him.
only if he gets it from somebody else running out of the building.
Exactly, or remained in the parking lot when the victim came out, because there were a lot of people who ended up with blood, with the victim's blood on them. And there was, I assume that there was a small amount of blood because nobody seems to have seen it on him, but he left a drop of blood in the Saturn. So, that probably goes to the weight of the evidence, but I think the identification was clearly the key issue at trial. And I think even with the blood and the DNA evidence, I think it is problematic because, again, even if you say that expert testimony should not have been admitted, or the judge was entitled to exclude the expert testimony, the instructions that were given were inadequate, and this court said that in Gomes.
Before you run out of time, could you address your hearsay argument?
The hearsay argument, I mean, that kind of bolsters the identification, because somebody unknown said to Mr. Faley, or he overheard somebody saying, Eric be buggin'. which would suggest that this defendant was out of control and was upset and therefore was the perpetrator. The problem was that there's a confrontation issue and there's actually a foundation issue because he said, well, I don't know if he said Eric be buggin' or E be buggin' or he be buggin'.
Isn't there another issue that inures to your favor, which is, actually, the testimony doesn't come in that the witness says that the out-of-court declarant said that Eric be bugging. He said that that's what he told the police.
I mean, I think none of it should have come in.
I understand. I'm saying that you're arguing that this spontaneous utterance of what he said he heard raises these issues of confrontation and of an excited utterance. I'm saying your argument's better than that because he doesn't testify as to what he heard. He testifies as to what he told the police.
I will take that.
Okay, any other questions? Thank you.
Thank you.
Okay, Attorney Shepard-Brick.
Thank you, Chief Justice Budd. May it please the Court, David Shepard-Brick on behalf of the Commonwealth. I'd like to start with the troublemaker because I think that's a bit of a distraction issue in terms of what the evidence actually was. Tony Taylor, who was the one who ejected both of these individuals, said that he described the troublemaker as a medium to light-skinned male wearing a tan leather jacket with embroidery and some type of hood. He described the assailant as a black-skinned male wearing a black jacket. And I would note that Taylor also described Reynolds as a medium-skinned male with no tan. So I think that sort of right out of the water says the defendant is not the troublemaker. He also testified that when he ejected the troublemaker, he simply pushed him out the door. He said, I pushed him out the door. I didn't go outside. I didn't see anyone outside because I wasn't outside. I just sort of pushed him to the door and he went out. He said that when he ejected the assailant, he carried him, bear hug, carried him to the door, and they both sort of tumbled out the door. And he said he dropped him on the door, in the door frame, or basically just right out the door. Both Ashley Hudson and Harmony Alvarado testified that they saw the defendant tackled out the door. So I don't think there's really any argument that, I mean, there is, obviously, but I don't think there's any really strong argument that the defendant is the troublemaker. In addition, I know there was some confusion between, I think it was Hudson who said mailbox door. Alvarado said, no, it was the entry door, which is the door the troublemaker went out. But she also was certain that that the people screaming and covered in blood came out the same door that the defendant was ejected, and there's blood all over the mailbox door, not the entry door. So again, she's clearly confused about which door. They also both testified that they heard panicked screams right before the defendant was tackled out the door. So that, and the testimony inside was there was a fight, there was raised voices, but certainly the screaming, as Jaskula testified, she started screaming once Mr. Reynolds had been stabbed. So the defendant comes out after the screaming, so there's really, again, no argument that he is the troublemaker. And then, of course, you have the blood evidence, which it's both on his jacket, which the testimony was, and the video evidence showed that he was out of the club, and the witnesses who saw him said, well, he was there for a second, this guy came out and joined him, then they ran over to the speeding's fine double sign, and then they were over at the racing mart. And you see in the video of the racing mart, the defendant has his hands in his pockets as he passes through the gas station. Shea testified that the assailant, he never actually identified the defendant as the assailant. He said, I believe he hurt him. All of the references to him being the stabber were struck from the record. His testimony was very clear. He didn't see the assailant. He didn't actually see the stabbing. It was just the person he believed had hurt his friend. He was the only one around who he didn't recognize.
So what he was doing on the witness stand was inappropriately drawing an inference, and when he would do so, the judge would strike it.
Yes, that's what happened. And I think through cross-examination and redirect, it was made clear that he actually had not seen the stabbing.
I get that, that you may be able to distinguish the two of them pretty clearly, but wasn't this still error not to allow, I'm not sure it's meaningful error, but the guy's an expert. He's pointing out the problems with this kind of identification, particularly during a melee. Shea's identification, he still believes it to be him. It's based on clothing. Clothing you tend to get confused. I don't know. Can we really say it's not an error to let this in? Because it still is an ID case in some fashion.
I think you can both say that it was not an error and that it was non-prejudicial. And one, I would point the court to Commonwealth versus Snyder, which is cited in the defendant's brief, 475 Mass 445. You're dealing with a very similar situation where you have a pre-Gomes trial, the same identification expert, it's Dr. Penrod. This court held that it was no error to exclude him and that the defendant wasn't prejudiced. And I think the lack of prejudice.
Can you explain, and I don't remember the case well enough right now, so tell me why we found it was an error with Penrod?
So, it's sort of the same reason that the trial judge in this case excluded him, which was, if you look at the voir dire of Dr. Penrod, he doesn't really discuss a lot of the issues that might be pertinent to this case. When he talks about the sort of identification of clothing versus facial versus, he said, there's one study I recall where it compared facial IDs to clothing IDs to voice IDs. He didn't really discuss it any further, whether it was whether it was dealing with people who knew the individual, but he didn't discuss a lot. He talked about how clothing could impact sort of photo arrays or lineups of that sort of thing. Shea was given a photo array and picked out another individual who he said was 80% sure that was the assailant. Which
so let's do Shea's for a second. So Shea identifies him by clothing, mostly by clothing, or how does he identify him?
He said that he saw part of his face, I think is what his testimony was. Obviously, the in-court is obvious. It's a facial ID. It has to be.
But doesn't Penrod say that when you identify, when someone's wearing distinctive clothing, that's the kind of thing that leads to bad facial identification?
He did testify that that is a factor to consider.
So is that a possibility here, too? Because the assailant is wearing distinctive clothing, a red brimmed or a red hat, and that's really what's triggering Shea's tracking of the guy, is his clothing, right?
I think there's
By the way, is the first guy thrown out wearing a hat or not?
Again, Taylor's testimony was, medium to light-skinned male wearing a tan leather jacket with embroidery and some type of hood,
So he's got a hood too. Okay.
which the assailant, the defendant, what have you, was identified as wearing a black jacket with a red cap with potentially black on it.
Can I ask one other thing?
Yes.
Because I did read the voir dire. The judge, and again, it's hard, he's being judged on standards that have changed, but
Right.
he's focusing in on corroboration, that there's corroboration. So is that right, that we don't care about when there's that kind of corroboration, we're not focused on ID issue problems?
I think what was happening there is he was sort of more looking at, there were certainly some older cases, but I think what he was looking at is the court said it wasn't prejudicial to exclude the testimony in those cases.
So it's really, the corroboration goes, just what we're talking about here, to the prejudice, not he focused, but he used it to prevent it from being admitted.
I think he did in part.
Yeah.
He also excluded it because he didn't find that it would be helpful to the jury on the identifications that were really at issue. And when he was initially put forward, he was put forward really for this gas station photo, identification. It's clear that you can't see, you watch the video, you look at those photos, you can't see a face. His friends watched the video and said, yeah, that's him, both because they saw him that night dressed that way, but they also, one of them had known him for 10 years. One of them was his cousin. So that sort of wasn't at issue. He really only goes potentially to the Shea identification, and I think the Shea identification is non-prejudicial because of all the other evidence. If there's anything else the court would like me to address, I can address the hearsay issue if you'd like.
That'd be great, Mr. Shepherd-Brick.
So if I had reread footnote 18 from Wordsworth, I would have used the primary purpose test from the outset. But obviously, it's not, the primary purpose of the statement was not to create a record for future prosecution. It's yelled out in a chaotic scene. It's
Well,
not.
here's my question. If the testimony was, I went and I read the transcript of the direct and cross, and if what was admitted in evidence was he did it, or Eric, then I would understand that you were dealing with what was arguably a spontaneous utterance and certainly wasn't to create a substitute for trial testimony. The problem is that when I went back and I read the transcript, that's not what came in. There's all this confusion going on during the testimony about whether they're dealing with a prior inconsistent statement, a refreshing recollection, or past recollection recorded. And what comes out of that sort of cluster is that the witness testifies as to what he told the police he heard.
Right.
Now, that raises issues. Not if the evidence had been as you're about to argue it, then I don't know that there'd be any issue.
Right. So, and my recollection of the testimony was that he told the police that he heard someone say he be buggin', and that in his statement it said Eric be buggin', but he never said that. That's my memory of the I know I read through it a few times. It's very confused in terms of what he's actually saying.
Well, on the witness stand, he's not owning that statement, but the out-of-court statement of what he told the police,
Right.
which was inculpatory, came in. And what he heard somebody say, you'd be fine, what you're about to argue, you'd be
Right.
fine, but that's not what happened.
Well,
The
right.
argument's better for the defendant than that.
Well, Right, so it really came in as a prior inconsistent statement, and the judge gave a prior inconsistent statement instruction in his final charge, basically saying that anything that a prior statement made by an individual is not offered for the truth. So I think that that instruction cures it because it tells the jury you can't consider that. So it was only admitted to impeach the witness, not for any substantive purpose. And so because of that, it wasn't admitted erroneously, and even if it was, it's a very, a fleeting statement. It wasn't argued in closing that to any significant degree, if at all. And the overwhelming evidence where his friends identify him getting thrown out of the club sort of cures any potential prejudice to that.
Mr. Curran provides an explanation of what Eric B. bugging means. Do you agree with that, or do you have any, I don't know what Eric B. bugging means. There's no testimony of what it means, I take it.
I don't think that there was. I recall there being some discussion. I don't know that it ever came in on the record about, I guess bugging out would be the sort of, that he's acting crazy, that he's, or that he's running away. Either one of those things. Again, it's sort of a non, I don't know that it's much of an issue, but yeah, I don't precisely know what they meant in that instance. If there are no further questions, I'll rest on my brief.
Okay.
Thank you.
Thank you very much. We're going to take a morning break at this time.